Welcome to The Explainer. Today, we're diving deep into an absolute game changer in the tech world. We're talking about the massive 2026 ruling from the Court of Justice of the European Union, or the CJEU, regarding Google's Android ecosystem. Now, this isn't just your standard story about a massive corporate fine. It is literally a masterclass in how modern digital ecosystems operate, how big tech licenses its products, and how international regulators are totally rewriting the rules for the future. We're going to unpack the mechanics of this verdict, the actual financial reality behind the flashy headlines, and the broader global ripple effects.
Here's our roadmap for today. We'll start with the final antitrust verdict, move into unlocking the Android ecosystem, discuss the battle over defaults, look at the legal precedent versus financial impact, explore the Digital Markets Act era, and finally, touch on global parallels and next steps. Let's jump right in.
Section 1. The final antitrust verdict. So, 4.125 billion euros. That is the headline number here. And to really grasp the weight of that number, you have to realize that this moment marks the end of an 11-year legal odyssey. It's wild. The European Commission formally opened these antitrust proceedings all the way back in April 2015. They issued their initial multi-billion-euro decision in 2018. Google obviously appealed, and then fast forward through a 2022 general court adjustment and a 2015 opinion, and we finally land at July 2nd, 2026. The CJEU dismissed Google's final appeal. This decision is completely binding. It officially exhausts the company's appellate avenues within the EU judicial system. But here's what's really interesting. This Android ruling isn't just some isolated event. It actually serves as the anchor in a decade-long sequence of European antitrust enforcement against Google. The Commission has pursued 3 major antitrust cases, resulting in over 8 billion euros in initial fines. Alongside Android, you had the 2.4 billion euro Google Shopping case finalized in 2024, and the AdSense case, which, interestingly enough, was actually annulled due to evidentiary errors. But Android has always been the centerpiece. It represents the EU's most ambitious attempt to regulate how a dominant tech platform leverages its mobile operating system. Moving to Section 2, unlocking the Android ecosystem. Okay, so let's get under the hood here to see why regulators were so concerned. Android is an open-source operating system, right? In theory, anyone can use it. But regulators zeroed in on a very specific web of contracts. First up, you have MADAs, Mobile Application Distribution Agreements. If a device maker wanted to offer the incredibly indispensable Google Play Store to their users, the MADA required them to also pre-install the Google Search app and the Chrome browser. Think of it like a master key system. You get free access to the building, but only if you agree to exclusively use the landlord's specific services once you're inside. And it gets deeper. To sign a MADA, manufacturers also had to sign AFAs, or anti-fragmentation agreements. That meant they literally couldn't sell devices running alternative, unapproved versions of Android, what we call Android forks. The European Commission basically said, no way, this is a single and continuous infringement. They deemed it illegal tying under Article 102, which specifically prohibits abusing a dominant market position. Section 3, the battle over defaults. This is where we see 2 totally different philosophies clashing. Throughout the whole litigation process, Google fiercely defended its model. They argued that Android is a highly successful, completely free engine driving global innovation. From their perspective, this ecosystem competes head-to-head with Apple's closed iOS, and these licensing agreements are just necessary to prevent software fragmentation and fund the free distribution of the OS, which ultimately lowers costs for you and me. On the flip side, the European Commission wasn't buying it. They didn't see standard business monetization, they saw structural ecosystem lock-in. Regulators successfully argued that these mandatory default placements erected massive barriers to entry. By requiring Search and Chrome to be front and center by default, they concluded Google made it structurally unfeasible for any rival search engine to get the query scale they'd need to compete. Now, to really understand why the EU won this argument, we have to talk about human psychology, specifically status quo bias. This is the proven behavioral reality that consumers rarely, if ever, go through the effort of changing a fully furnished default setup on their phones. It's exactly like buying a fully furnished house. You technically have every right to replace all the furniture, but the effort required means most people just keep the existing setup. Regulators argued Google exploited this exact bias. By locking in default placements on the vast majority of mobile devices, they ensured competitors couldn't gain a foothold, no matter how good their alternative products might be. The courts agreed that in digital markets, this simply unlawfully excludes competition. Which brings us to Section 4, legal precedent over financial impact.
So we're back to that historic 4.125 billion euro penalty. Now, in a vacuum, that sounds like an absolutely staggering amount of money, right? It's literally among the largest antitrust penalties ever levied globally. But to look at this objectively, we have to contextualize it against the massive scale of the company actually paying it. Because when you pull up Alphabet's financials, it paints a totally different picture. In fiscal year 2025 alone, Alphabet reported over $132 billion in net income. Plus, they had already provisioned a $3.5 billion charge for this exact fine back in the third quarter of 2025. So when you juxtapose a €4 billion fine against $132 billion in pure profit, it becomes crystal clear this penalty is essentially an absorbed operational cost. It's not some fatal structural financial threat. It certainly does not break the company. The primary business impact isn't actually the cash outflow at all. It's the strategic adjustments they have to make to manage new, unbundled licensing and choice screens across Europe. The true weight of this case is the legal foundation it establishes.
Next up, Section 5, the Digital Markets Act era. You see, traditional antitrust investigations are entirely retrospective. They look backward at past behavior, and as we just saw, they are incredibly slow, 11 years from start to finish. By the time a verdict is reached in the tech world, the market has completely evolved. But the legal theories that regulators successfully validated in this ruling provide the rock-solid foundation for the EU's new Digital Markets Act, or the DMA. The DMA is a total paradigm shift. It moves the strategy from punishing past behaviors to proactively regulating tech gatekeepers before monopolies can cement themselves. It explicitly targets the exact types of tying and self-preferencing behaviors that were identified in this Android case.
Finally, Section 6, Global Parallels and Next Steps. Regulators all over the world are waking up to the power of ecosystem defaults. We're seeing simultaneous scrutiny in the United States, the UK, Japan, and South Korea. In the US, a federal judge recently ruled on Google's exclusive search default contracts. In Japan, they have a new law mandating search engine choice screens. The UK's Competition and Markets Authority is proposing new conduct requirements. And in South Korea, authorities are actively investigating developer incentive programs.
But here is a really crucial piece of context we need to keep in mind. These global investigations are parallel actions, operating under distinct domestic laws. They are not some direct domino effect consequence of the EU's specific ruling. The European decision is definitely a major reference point for sure, but each jurisdiction is operating totally independently based on its own specific legal statutes and market realities. So looking ahead, say over the next 12 to 24 months, what should we actually be watching? First, market share. Despite years of remedies, as of mid-2026, Google still retained an 88.6% search market share in Europe, and Chrome held over 56% of the mobile browser share. Will these numbers actually start to shift? Second, we really need to watch Android OEM behavior. Now that the legal standing is clarified, will hardware manufacturers actually use their new flexibility to negotiate better revenue shares, or maybe experiment with localized Android forks in Europe? And lastly, we have to monitor the ongoing DMA interoperability enforcement to see how seamlessly competing services can interact with the Android base. Which leaves us with a really fascinating data-driven question to ponder as we wrap up this explainer. Will structural remedies like mandated choice screens actually break deeply ingrained consumer habits, or will behavioral friction keep the status quo totally intact? The EU has decisively won the legal war to regulate ecosystem defaults, but the empirical evidence on whether a choice screen can actually overcome the familiar comfort of a known brand is still very mixed. The courts have spoken, the fines are locked in, but the ultimate decision of market dominance now rests right where it always has, in the daily habits of billions of smartphone users. Thanks for joining us for this explainer.